All right, Mr. Garcia, you ready? Tell me what you got to tell me.
May it please the court, counsel. Judge, what has brought us here Wednesday and Friday of this week? I would submit to you the last words of Chad Olson. I can't believe he shot me. The law is clear in this case, Judge. We have the burden of proof, not only by beyond a reasonable doubt, but by all doubt in this case. And we have to prove to you that the proof is evident and the presumption is great that this defendant, Curtis Reeves, committed second-degree murder on January 13th of 2014. I would submit to this court, contrary to what Mr. Escobar has argued, that the state's witnesses are not credible, they're all over the place, so on and so forth. But two things that are consistent with all four of those main witnesses, Judge, are that they never saw Chad Olson strike, touch, hit, or even throw a cell phone at Mr. Olson. You heard Mr. Cummings, and Mr. Cummings told you from the very beginning that Mr. Reeves was agitated. He was angry as he walked out of the theater. He kicked the back of his chair. What's also consistent with all four of those witnesses, they all say it was popcorn and nothing more but popcorn. What evidence does the state have to corroborate the testimony of those witnesses, Judge? And I would submit to you that we have photographs, which obviously you have seen, and I would invite the court to look at again, of Mr. Reeves on January 13th of 2014. And it shows that he absolutely has no injuries upon his face. None. Mr. Escobar would want you to believe, or the court to believe, that he may or may not have injuries had a cell phone been thrown at him. I would beg to differ with him, Judge. If a cell phone had been thrown at Mr. Reeves' face, there would be injuries depicted in these photographs. And there's absolutely not even one scintilla of evidence that he was struck in the face. Let's look at the statements that were made by Mr. Reeves in this case when he was interviewed by Detective Alan Proctor. As far as ill will, depraved mind, hatred. It was crazy. It really was. It was completely uncalled for. Good heaven, I didn't mean to do that. That was just, I had to say, that I've counseled cops for. Out of his own mouth, Judge. Good heaven, I didn't mean to do that. Not, I acted in self-defense. I just got hit with the cell phone on the side of my face. He threw a cell phone and hit me. But good heaven, I didn't mean to do that. What else do we know, Judge? You know that Mr. Reeves, in talking to his wife, she indicates to him there's no justification for what happened in there. What's more interesting and more telling, Judge, is that when Mr. Escobar kept saying, look at the state's witnesses and determine their credibility, and you'll find that they're not credible, so on and so forth. I know you've heard the audio, but I would implore the court to go through your notes. I know that you took copious notes, Judge. And Mr. Reeves says on the interview, you know, I don't know if I was saying no, 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 or whoa, whoa, whoa. So he's coming over on me. I'm pushing him off with my left hands. and I had a hold of something. I'm assuming it was probably his chest. I don't know. Where in that video is that depicted, Judge? Where in that video do you see Mr. Reeves holding Chad Olson back like he's describing? I either was touching his arm, his chest, or his shoulder.
Hey guys.
Sorry we're late.
Did you run into traffic?
No, just had to stop by the house to grab a few things.
You stopped by the house?
Yeah. All right, whenever you get your stuff, run upstairs, get cleaned up for dinner.
You leave the house in good shape?
Yeah, of course.
Last second field goal.
Yeah, sure you did.
Introducing AT&T Digital Life. Personalized home security and automation. Get professionally monitored security for just $29.99 a month with limited availability in select markets.
Another one of his statements. Oh shit. This is stupid. Judge, and more telling is that when Corporal Alan Smith is on the witness stand and he hears conversations between Mr. Reeves and his wife, that his wife, after he makes a statement to her, she turns to him and says, there was no reason to do what you did.
You mean Corporal Hamilton?
Corporal Hamilton. What did I say, Judge?
Alex Smith.
I'm sorry, Judge. I apologize. He then turns to his wife, and what does he say? He points at her and says, shut your fucking mouth and don't say another word. Why? Because he knew what he had done was wrong, Judge. He didn't want his wife saying the truth. And what's the truth in this case? What statements do we have from Vivian Reeves? Detective Proctor asked Mrs. Reeves, did you see him get hit in the face? No. Did you hear a hit? And he even demonstrated on the audio, Judge. If you recall, he smacks his hand and said, did you hear a hit? No. Did you see any injuries upon your husband, Mr. Reeves' body? No. Any indications that he had been hit? Was there anything, Mrs. Reeves, on your husband's body that would lead you to believe your husband was struck or hit? No. Did Mr. Olson ever threaten your husband? No. And more telling, this defense that a cell phone was thrown, Mrs. Reeves was right next to him, sitting right there. Did you ever hear her say to Detective Proctor, Mr. Olson threw a cell phone? I see a cell phone come flying by? No. Why? Because it didn't happen, Judge. That's why. She specifically said that she had not heard Mr. Olson make any threats to her husband, Mr. Reeves. Detective Proctor goes back and questions him further, and he says to him, you keep saying he hit you, but what does he hit you with? Mr. Reeves, it's dark. I don't know. Originally, he had said, I thought it was a fist. I thought he may have thrown a cell phone or hit me with the cell phone. Bottom line, Judge, is it didn't happen. For the sake of argument, and should this court believe, Mr. Escobar, that the shiny light on the video was in fact a smartphone, obviously we're not saying that it was, we're not admitting that it was, Judge. First of all, why would somebody throw a $500 or $600 cell phone at someone? And then why would Mr. Reeves wait 13 seconds after that shiny light before firing his gun? Is that reasonable? I would submit to you that based upon the video in this case, and the only one that's aggressive in here is Mr. Reeves. From the minute that he gets in that theater, and take it, Judge, you can see the theater's empty. There's hardly anyone there to see the showing. Why does he go and sit directly behind Chad Olson? Because Mr. Reeves has appointed himself as the texting police. He's going to tell him because, as Mr. Escobar said, he has 27 years of law enforcement, all this tactical training, all this experience. And by God, he's going to go in there and he's going to sit behind Chad Olson. And you saw in the video, within seconds, he sits down. And within seconds, he's tapping him on the shoulder. Hey, you need to turn that off. Then he sits back. And a second or two goes by, and what does he do? He reaches over again and tells him, you need to turn your cell phone off. Anywhere in that video, do you ever see Mr. Olson during those encounters turn around and speak to him or say anything to him? Obviously, you don't see him in the video. Then the third occasion, he's sitting there and he moves forward again, another conversation. Okay, you're not going to turn the cell phone off? I'm going to see the management. He leaves and goes to see the management. He shortly comes back there afterwards. Now he sees, and it's corroborated through the testimony in the taped interview of Miss Olson, that her husband had put the cell phone away. So instead of just going back to his seat and not saying anything, he has to engage him again and say, oh, so now that I've gone to management, now you put your cell phone away. And then what transpires, Judge? I would submit to you what transpires is that Chad Olson stands up. He is extremely angry at this point after Mr. Reeves has confronted him at least on 3, if not 4 occasions about the cell phone, and he's had enough. There's various versions of what he said. Some people say, I was texting my fucking daughter. If it was any of your business. I had just gotten a phone message. I was checking on my daughter, so on and so forth. What you see in that video is you see Chad Olson reaching over, grabbing the popcorn out of Mr. Reeves' hands, and throwing it at his chest. And I would submit to you, Judge, as far as testimony about the gun being drawn and so on and so forth, if you look at that video, Judge, there is absolutely no way, I don't care how many times he's drawn that gun from his pocket in the fluid motion that Mr. Turner talked about, I would submit to you, Mr. Reeves was ready and waiting for Olson. He was ready and waiting for a confrontation. It's almost instantaneously. The popcorn is thrown, the popcorn is still in the air, hasn't even hit him when the gun is pulled out in front of him, because he said, according to his testimony, it was in an upward trajectory. If you look at that video, his arm is straight up. The other important and interesting point that was brought out through Detective Aaron Smith is that you heard that the difference in height between row B and row A is 10 inches, Judge.
I did hear that.
So 6'4" Chad Olson would not be 6'4" standing in front of Curtis Reeves. You would have to take 10 inches off of his height, which would put him basically directly in front of the defendant.
Was that true if he was sitting though? Which he clearly was sitting, so now it's just a 5'4" guy standing in front of him. Right?
Right,
Okay.
correct.
Tell me, highlight, spotlight, what you've told me so far though, that gets you past the many cases the defense has cited as it relates to second-degree murder.
Absolutely, Judge.
All right.
I can point you directly to it.
Point
And that's the
point me to it.
statement. That is the statement from Derek Friedhoff. If you recall, the statement from him was, I'll teach you to throw popcorn at me. And he fires the gun at Chad Olson. that is a person with a depraved mind. That is a person with ill will. That is a person with hatred. I can cite to you Judge, our case law is clear in this case, Judge. The cases that I've cited.
Tell me those cases again. You say the ones that are in your memo.
Yes, Judge, the ones that are in the memo, starting off with Keltner.
Which page of the memo was it again?
I'm sorry, Judge?
Which page of the memo was it again? Keltner, there it is. It's on page 2 at the top.
Yes, Judge. But citing the court to Keltner, Judge, under Head Note 1, and it's for the record, Keltner is Keltner versus State of Florida. And it was decided February 17th, 1995. It was a second DCA case. Keltner contends that the evidence was insufficient to warrant the jury's finding that he evinced a depraved mind in shooting the victim. From our view of the evidence in this case, we find that the act of pointing a loaded firearm in someone's direction and then firing it is imminently dangerous to another and evinces a depraved mind.
All right.
And then it cites to the other cases of Brown and Edwards. And I think in one of those cases, the defendant fired at an individual and struck him in the leg, and the court likewise says that constitutes ill will, hatred, and a depraved mind, Judge, when you point a gun at someone and you fire it.
Does that mean that every gun death has to be second-degree murder? It can't be manslaughter?
No, I'm not saying that, Judge. It depends upon the facts and the circumstances in this case. In this case, Judge, our contention is they have not established self-defense in this case. And through his actions, pointing the gun, firing the gun, and his statements constitutes second-degree murder.
Keltner seems to be a little light on facts. It's a one-page decision.
Well, Judge, here's another case. I would cite the court to Edwards versus State of Florida, which can be found at 302 Southern 2nd, 479, a third DCA case, which was decided November 3rd of 1974. Under Head Notes 3, 4, and 5, as defined in 78204 Florida statute, murder in the first degree requires premeditated design, as this court is well aware of. And murder in the second degree requires an imminently dangerous act evincing a depraved mind regardless of human life. It is well established the state of mind may be inferred from one's actions, and the murderous intent may be established by the facts and circumstances of the case, such as a weapon being directed at some vital spot on the assaultee's body. I would submit to you that Mr. Reeves, in pointing that firearm directly at Chad Olson's chest, what other intent did he have, Judge, but to kill him? It's not like he shot him in the leg or shot him in the arm. He shot him in the dead center of his chest.
What am I to make, though, of all the defense's cases that talk about an overreaction to a sudden provocation and fight? Is manslaughter not, for instance, he said, I thought I was going to get my ass whipped. Say that self-defense isn't appropriate and say that everything that you proved is correct. How is simply shooting him as an overreaction not the manslaughter that half a dozen of the defense's cases point me to, and some of them are second DCA cases fairly recent?
Judge, because I think in this case you have the ill will that's necessary for the second-degree murder by his very own statements. I'll teach you to throw popcorn at me, and fires. That is a time to reflect. As the court is well aware of, Judge, the time to reflect is only the time necessary for reflection. You see a dollar bill on the ground, you stop, so I pick it up. That's establishing premeditated murder, Judge. In this case, I would submit to you, his reflection, it wasn't like the popcorn was thrown and he was hit and automatically he fires, but you heard the testimony from the witnesses, especially Mr. Friedhag. He testifies, I'll show you to throw popcorn in my face, and then fires. Center mass. What other intent does he have but to kill Chad Olson? Furthermore, Judge, does a reasonable citizen carry a loaded firearm in a theater in violation of a posted sign that clearly says no firearms? If he had left the firearm in his car, we wouldn't be here today. This would have never have happened. Clearly, his actions on January 13th of 2014, Judge, and I would submit to you that the state of Florida has not only proven this by proof evident presumption great, we have not only proven it beyond and to the exclusion of every reasonable doubt, but of all doubt, Judge. There was no reason for him to shoot Chad Olson with a firearm and kill him. Even assuming that he had been struck, assuming, arguendo, that he had been struck with the cell phone. You know, Mr. Escobar kept talking about the self-defense, the stand your ground, a forcible felony. Well, Judge, in our memorandum, in our response to their motion to set a reasonable bond, I think the case law is very clear, Judge. In Nelson versus State, the issue for resolution was whether the trial court erred in classifying Nelson as a prison re-releasee reoffender on the two convictions of a battery of a person 65 years of age or older pursuant to Section 784.08, subparagraph 2C of the Florida statutes. In State versus Hearns, which is found at 961 Southern 2nd, 211, a Florida Supreme Court case of 2007, the Florida Supreme Court looked at the elements of the offense charged, battery on a law enforcement officer, and determined that since a battery could include a mere touching, it would not necessarily be a forcible felony under the PRR statute. We conclude that Hearns applies to the incident charges and that Nelson is not subject to sentencing as a PRR for the two battery offenses. Battery of a person 65 years old or older is neither an enumerated felony, nor does it contain the necessary element of the use or threat of physical force or violence against an individual. See 784.08 subparagraph A, C of the Florida statutes, 2004. In Hearns, 961 Southern 2nd, 216, the court reiterated that the only relevant consideration when determining whether an offense constitutes a forcible felony is the statutory elements of the offense. If the use or threat of physical force or violence against an individual is not a necessary element of the crime, then the crime is not a forcible felony within the meaning of the final clause of Section 776.08.
All right, let's go one step further, looking logically at the construction of the statute when, for instance, when the state brings a case and they calculate the criminal punishment code for purposes of scoring out a sentence. If you bring me a charge out of Georgia where it's a misdemeanor, but in Florida it would be a felony, should I look to the elements of the offense committed, or should I look to the elements that are delineated within the Georgia statute to determine whether it's a felony or a misdemeanor for purposes of scoring?
Well, you should look for the elements for purposes of scoring, Judge.
And then factually, in this case, should I look to simply the idea that battery on a person 65 years of age or older could be a touching against the will, or it could be, as charged in B, causing injury, which is what they're alleging. They're alleging that it was by causing injury from the striking with the phone, not simply an unwanted touching.
I understand that, Judge. However, it's not a forcible felony to where you can pull out a gun and shoot and kill someone.
I'm not saying that. I'm just asking, can it be classified if they're asserting this defense? And you're saying stand your ground as though they've actually asserted that. I don't think they've actually asserted that.
No, I'm not saying that, Judge. I'm just saying in looking...
I actually want to get that clarified because, and I hate to use those words because it makes everybody run in different directions and say things that aren't necessary to be said, and it's certainly a phrase that when you touch upon it, everybody goes wild, but I can't avoid it anymore. Are you asserting stand your ground here?
Your Honor, at this point, it's too early in this case to assert any of that. What I did, if the court reflects on it's on page 5 of my memorandum, you'll see that I cite not only 776.012, which is what's contained and stand your ground, but more importantly, 782.02 doesn't even talk about a forcible felony. It says felony, any felony.
I know, and that's why I'm going through it, but I want to make sure that everybody has it correct, what's going on here. Are you at this point asserting stand your ground or any
No.
variation of stand your ground within the statute?
No, Your Honor, the only thing that we've done is that we've made the laws available to the court for the court's consideration on both sides, and that's why we went through great lengths to show that, the 6-foot wall was right behind Mr. Reeves, and it wouldn't be reasonable for him to be able to flee Mr. Olson, because again, he was over the backrest of Mr. Olson. So that was the whole purpose of doing this. So if he has a duty to retreat, guess what? He wasn't going anywhere.
I heard your frequent and vivid references to the 6-foot wall many times, and I understood that, but I also just want to make sure that we're clear. You're not asserting stand your ground at this time. I'm not foreclosing you from doing it, but I want to make sure that it's clear. That's not something you're asking me to consider right now in any way.
Not to consider this at this time, Your Honor, but I would consider, along with these statutes, you've got to consider all the physical evidence, including the autopsy that clearly shows.
I'm going to look at all the evidence
Okay.
before I rule. Don't worry. I'm going to
Okay.
take it all back to my chambers, and I'm going to take 10 to 15 minutes to go through it all again. I looked at it this morning as soon as I walked in here. I'm going to look at it all again, especially the new stuff. So I just wanted to make sure that we're clear. You're not asserting stand your ground. I'm not keeping you from doing it later, but that's not what we're doing today, okay?
Your Honor, in a bond motion like this, you don't assert stand your ground.
Right. It's an immunity.
It's a consideration of the law that you have to consider, but we're not asserting it now because we're not in a stand your ground posture.
Right. I just making sure. Okay, great. You may continue, Mr. Garcia.
Judge, did I answer the court's question? Or I think we may have cleared up the issue as to the stand your ground defense.
That was what I wanted to get that out of the way before we went any farther. I'm still listening for anything additional you want to tell me on why this is second-degree murder and not manslaughter, if you prove it beyond to the exclusion of every reasonable doubt, and I don't believe that there's self-defense. Why is it that it's second-degree murder and not manslaughter?
Judge, and I think, not to be repetitive, I think I set it out in the state's response as to the cases that we cited as to the gun. And mindful, Judge, the uncontroverted testimony from this witness stand was Mr. Reeves shot an unarmed man. It wasn't self-defense. They all indicated they never saw a hit, they never saw a strike, they never saw a cell phone. They saw popcorn being thrown. Does popcorn justify him pulling out his firearm and shooting Chad Olson in the chest? No. I would submit it does not, Judge.
How about this? On that video, there is a light. I don't know what that light is. I know what Mr. Escobar wants me to believe that light is, but I don't know what that light is. Not yet. I could infer what that light might be. What do you think that light is based on everything that we've got going on here in the way of the testimony and evidence that we've heard from the bond hearing? What should I believe that light is?
I don't know, Judge, to be quite candid with the court. And I don't think the court can assume what it is or have conjecture as to what it is. Mr. Escobar doesn't know that that's a cell phone. He can't stand up here before this court and say it's a cell phone.
No, he did.
I know he did, Judge, but it's pure speculation and conjecture on his part. It's an assumption. We don't know if that's a glitch in the camera, the light that you see. We don't know if that's Mr. Reeves' cell phone that has fallen or Mrs. Reeves' cell phone that has fallen. Why is he asking about his cell phone? Ask yourself, he's thinking that he lost his cell phone. We don't know what that is, Judge.
Say I believe it is the cell phone. How does that affect the ruling that I should give at this time?
How does it affect the ruling? Tremendously, Judge, because if you in fact believe that that cell phone was thrown at Mr. Reeves, 13 seconds goes by before he shoots him. That's ill will. That's hatred. That's having a depraved mind. That is second-degree murder.
Okay. Anything else you want to tell me as to why I should find proof evident presumption great? Because while I've not yet made my decision, when I do make my decision, if I decide you've not met your standard, I want to hear your input as to what you believe I should do if I decide to give a bond, whether it should be a monetary bond, and if it's a monetary bond, I'm going to ask you what you think the amount should be. And then I'm also going to ask what other restrictions you think I should put on Mr. Reeves in the event that I give him bond.
Judge, in all candor with the court, the state's position is that we would obviously ask the court for no bond. However, if you find that we have not met our burden by proof evident presumption, great, and you are inclined to set a bond, I would ask this court to set a bond in the amount of $2 million. I would ask the court for him to surrender his passport. I would ask the court to impose the fact that he cannot go to the movies or attend any other movie theaters.
That's a given, I'm going to do that.
Well, Judge, because quite frankly, Judge, you know, the citizens of Pasco County have a right to be protected from people as Mr. Reeves in this case, Judge. He was a ticking time bomb that day, Judge.
All right.
And he exploded.
I understand that, but I'm looking also at the bond schedule. If I decide you've not met your burden, the bond schedule suggests that for a life felony, including homicides, low bond's $100,000. High bond is none. In the state of Florida here in Pasco County, because we have the numbers and they're always given to the judges, I've had a chance to take a look at the numbers. Do you know how many second-degree murders we have pending in Pasco County right now? 13 of them, 5 of them have bonds in the amount between $100,000 and $500,000. 8 of them have no bond. What bond should I set for him? Nobody's got, well, actually, I think one had $750,000. Nobody's got one more than $1 million, and the ones that have the higher bonds have other situations going on. This gentleman has no prior record for the entirety of his life, and why would I set a $2 million bond for somebody with no prior record?
Judge, that's because the state of Florida feels that strongly about this case and the safety of the citizens of Pasco County. Judge, we firmly believe that second-degree murder has in fact been proven here. I understand the court may or may not have a finding and disagree with us, Judge. If you feel that $2 million is excessive, and in conjunction with the bond schedules, you're saying it could be from $100,000 to no bond at all, then I would submit to the court, Judge, that we would ask for a $200,000 bond, should the court decide to set one, that all the firearms in the possession of his son be relinquished to the Pasco County Sheriff's Office.
All the firearms that he owns.
That he owns that are in possession of his son. We would ask that his passport be surrendered to this court. In addition, again, I think to reiterate, you've already considered that as part of the bond conditions, should you set it, is that he is not to attend any theaters. And I would say, Judge, either in Pasco County or any other county in the state of Florida.
Just so that nobody has to worry about this in the event that I grant bond.
He's not going anywhere?
I've not made a decision yet, but in the event that I grant bond, I'm going to order that he remain at his house. He can go to church and he can go to the grocery store, but that's it. Unless he has some other special function that he wants to attend, and he's going to ask the court's permission in advance if I decide to do that. Mr. Escobar's already volunteered that he's basically willing to be on house arrest. If I let him out, I'd let him go to church and I'd let him go to the grocery store if he felt it was necessary. Of course, I'd probably counsel him that's a bad idea also, but
Judge, I would also ask this court to consider putting an ankle monitor on him.
and I'm going to do that also if I grant bond. Again, I'm still on trying to figure out what to do here. I'm going to review all my notes, and I'm going to review the evidence, and then I'm going to give you the answer. But anything else that you haven't covered with me yet?
Yes, sir.
That you want to
Judge,
cover?
as far as presentation, Judge, the only thing that I've asked, as I've indicated to the court, and I would reiterate one more time, the state of Florida feels strongly that this has been proven by proof evident presumption great, that we have not only met our burden by proving it beyond a reasonable doubt, but all doubt that the defendant committed second-degree murder on January 13th of 2014, and we would respectfully request that his bond remain at $0.
All right.
Thank you, sir.
Thank you, Mr. Bershay. Mr. Escobar, I'm not in the habit of doing it, but if there's anything that he's addressed specifically that you feel that I should have readdressed to me in a very limited fashion, I will let you do it, because I need to make sure I've made the right decision here, and I want to hear from everybody as much as I can.
Your Honor, one of the things that he mentioned is, why would Mr. Olson throw his phone? I think that's very reasonable that Mr. Olson would have thrown his phone, because the phone is what actually caused Mr. Olson's anxiety over this whole situation. He was texting He was using his phone, and that's what precipitated this whole issue. I could see very easily him getting so frustrated over the situation and getting so out of control. We know he got out of control. No one can dispute that Mr. Olson was totally out of control. Whether he threw a phone like this, or whether he...
Objection. Okay, this is not another argument. I think you want something specific. And
Yeah,
want you to give us
I was hoping that, I mean, is there anything specific? I get what your inference that you're drawing, and I get what his inference that he's drawing. I understand that, and you two will never agree on that. And when you say nobody can disagree, I bet you I could find a couple people in the audience that would disagree with just about anything that gets said today. I'm just talking, is there anything within the law that you disagree with that Mr. Garcia asserted that you haven't already told me about? Because that's what I'm looking for. I have to apply the law to the facts and come up with this decision. I don't need any more of the emotional argument. I just need the law to the facts. Is there anything left that I haven't considered, asked you about, asked him about? I've asked you both some tough questions because I wanted to hear your answers, and you both have answered me, and you've given me a lot to think about. Is there anything else that you thought of while Mr. Garcia was talking that you thought, Judge should have asked him this, or Judge should have asked him that?
No, Your Honor, I
Okay.
think I've laid the law in my memo.
All right, well, great. Then we're going to take 15 minutes so I can go and look at everything, and I'll come back and tell you what's going to happen.
All rise.